Ruled that the South African Police Service has discriminated against Lt-Col Renate Barnard on the basis of race. The SAA upheld an appeal against the decision of the Labour Appeal Court that overturned the decision of the Labour Court. The Labour Court held that Barnard had been unfairly discriminated against when she was not appointed to the position of superintendent within a specialised unit of the SAPS, despite being the best candidate for the post. The Solidarity Trade Union helped Barnard with a legal battle. Now, to talk to us about this discussion, we're joined by the Labour lawyer from Global Business Solutions, Jonathan Goldberg from our Cape Town studios. Jonathan, good morning to you.
Good morning to you and your viewers.
Jonathan, how significant is this ruling in redressing the imbalances of the past, of course, considering factors like affirmative action?
I think it's very significant because it gives us some clear direction in terms of implementation. And you know, there have been a number of cases that have come out the Western Cape and KwaZulu-Natal in respect of Indian and coloured appointments and appointments not being made. And this case gives us some guidance in respect of implementation, specifically around setting absolute barriers to certain race and gender groups.
Would you say that this is a common problem in the workplace, especially government departments and the police service?
I think it is a common problem where people have implemented employment equity very rigidly. So unless you meet the criteria, you don't get appointed. And in Captain Barnard's case, she was a captain at the stage. She applied for the job twice, got rejected twice in terms of the fact that she wasn't the right composition. They were looking to redress their imbalances specifically on African males and females, and because she wasn't from that denomination, she was not appointed, albeit that she was by far the best candidate and recommended by a very open panel. So the panel was very representative of the police force, respected demographics, and they strongly recommended her both times, and she was refused the actual post. And that's really what this case is about, is can you set absolute barriers? And the Act is very clear, Section 15, together with the amendments that are coming out, that you cannot set absolute barriers in terms of implementing employment equity.
Now, discrimination in the workplace seems to be leaning towards race. Would you say that this is the case, or are people also discriminated more based on other things?
I think worldwide we're grappling with the issue of discrimination in the workplace. And I think there is discrimination in the workplace both in South Africa and other countries, in most other countries. And I think it's how you grapple with it and what systems and methods you put in to implement non-discrimination in the workplace that is important. Now, remember, employment equity is intervention. The Constitution doesn't allow you to discriminate. Employment equity and the Employment Equity Act is intervention to redress the imbalances of the past. And this case and the other cases are really about how you do so. So if you set absolute barriers, clearly that's not what you're allowed to do. You can promote, develop, and give advantage to people who are either suitably qualified or who have the potential to be suitably qualified. And I think that's the problem in South Africa. No one's looking at the potential and suitable qualified people to really fast track those people into the workplace, because we need the majority of South Africans to be part of the economically active working population.
Now, a few weeks ago, we had a chat with you about the High Court ruling on employment equity and the Department of Correctional Services. Would you say that these cases are similar?
I think all these cases are in a similar vein in terms of they were looking at the national demographics and only appointed people based on the national demographics. And there the question was, do you apply the national demographics rigidly? And the courts are saying, no, you've got to use a blend of national and regional demographics. And this case goes one step further to say you've got to have some rationality to the fact that you don't appoint someone like Captain Barnard to that position. There must be a rational connectivity between your plan and your non-appointment. Remember, Barnard, being a white female, is from the designated groups. But in their case, they were saying they were overrepresentative of white females in those categories.
Now, does the private sector have similar problems, or is it more infested in the public services?
I think going forward, you're going to have these kind of problems in the private sector, specifically with the changes proposed to the employment equity, where you have fines in the first instance of up to 2% of your turnover, as well as a much easier Section 42 compliance section. I think employers are going to be quite forced to try and ensure. Yes, I can.
Yes, Jonathan.
I think employers are. Employers are going to be forced to try rapidly promote and develop people. And I think these cases give us very good guidelines in respect of how you're meant to do it. If you're just trying to replace one race for another race, I think you're going to be in trouble. But if you do it with a rational connectivity, with some plan, and I think that's what the problem is. For maybe 18 years, we haven't done things as we should have done for the long term. I think all employers, both government and private, have to start looking at the long term, putting the building blocks in place for rapid growth and development of majority of our population.
So, Jonathan, how do employers now plan and really make sure that they stick to the letter of the law?
I don't think we're doing enough in terms of development of potential in this country. So in other words, identifying people that are already stretchable in terms of development and applying our resources into that. I'll give you a simple example. I've got a workplace of 3,000 people on the factory floor. They're mainly African and female, African male and female. Surely there must be 1% of those people that are promotable to senior management ranks over the next 5 to 8 years. It's identification of those people and fast-tracking those people that I think is critical in this country. And I think there's a latent opportunity there. I think there are people with potential. We need to find ways and means of fast-tracking it. And unfortunately, I don't believe our education system is necessarily delivering the type of people that are ready for work. And I think companies, both government and private companies, are going to find innovative methods to substitute those particular development plans to fast-track those individuals.
Now, where does employers get more information in terms of this?
Well, I think employers have been doing employment equity for some time. I think it's a re-looking at these processes for the departments who are like the police services, the correctional services department. I think they're going to have a re-look completely at the way they implement employment equity, and these cases say they need to do so. I think for private employers going forward, specifically with the new amendments, I think one's going to have to regroup strategically and say, where do we get our best spend for money we spend, and how can we fast-track African, coloured, Indian, and where we underrepresent, of course, white women are also in the designated group.
Jonathan, thank you so much for your time.
Absolute pleasure. Thank you.
And that is Jonathan Goldberg from Global Business Solutions joining us. He's a labour lawyer joining us in our Cape Town studios.